Just before the 4th, a major update in one of last summer's episodes of riot violence snuck in. Recall last July in Austin, Texas, there was what would have otherwise been your typical mostly peaceful racial justice protest, with the mob marching through the streets like they own them, even though the streets aren't closed, surrounding and threatening any car that has the audacity to try to make its way through the roadway. Your usual scenes, except for this one, ended in lethal defensive gunfire against the mob. And if you don't remember the story based on that scene, you will surely remember it based on this one. The man who was shot was carrying a gun openly himself. His name was Garrett Foster. He was armed with an AK rifle. And just before this incident, he was interviewed saying that his political opponents are too big of pussies to do anything about him and his friends running the streets.
AK-47. What you got it out tonight?
They don't let us march in the streets anymore, so got to practice some of our rights. I think all the people that hate us and, want to say shit to us are too big of pussies to stop and actually do anything about it.
And of course, it was a claim that aged as well as expired milk left in the sun, because as soon as Foster challenged somebody to do something about it, somebody did something about it, and that's why Garrett Foster was put down on the asphalt that night. The incident started when Army Sergeant Daniel Perry, who was driving for Uber at the time, tried to make a right-hand turn among the protest marchers. And again, all of these streets are publicly open at this time. None have been closed for protest activity. After Perry tries to make his way through the crowd, he stops as protesters obstruct him. More protesters then swarm and surround his car, and shortly after they do, gunshots are heard. Those are shots from the driver, Daniel Perry, shooting Garrett Foster dead. And why Garrett Foster? Well, because he's the one wielding the AK that supposedly nobody will do anything about. Foster is visible on some video angles lunging at Perry's car with the AK. Now, I've not seen a definitive image of Foster pointing the AK at Perry or the car. His muzzle is down at the ground in this particular image, though he's clearly advancing on the car. But multiple witnesses claim that Foster pointed his rifle at Perry before Perry shot Foster, and that the mob was beating on Perry's car throughout. Both have been consistent claims of Perry's legal team throughout this case's development. For his part, Sergeant Perry left the scene and immediately called 911 to report the incident. He then surrendered to police and fully cooperated with the investigation. Now, the case against Perry portrays him as the aggressor. There are other witnesses who say that Foster didn't raise his rifle and that Perry aggressively used his car as a weapon, and that prior tweets from Perry show hostility toward rioters. So the claim is that Perry went to Austin with some sort of malicious intent to attack activists, even though it was his Uber driving job that brought him there. Conflicting claims aside, Perry was released after the incident and his questioning, and since, it's been a lot of crickets. And I wasn't expecting much to come of this case, because based on a combination of the facts and Texas law, it seemed like justice was served. It's unfortunate that Garrett Foster lost his life, but when you threaten someone else's life, losing your own is a possible and justified consequence. And Texas law enshrines that principle. Texas is a stand your ground state, meaning citizens are justified in using deadly force if they reasonably believe they are threatened with serious harm. And even if Foster never did point that rifle, a mob surrounding your car and beating on it and bringing in a rifleman to enforce this improvised checkpoint, even muzzle down, you can credibly argue would put a reasonable person in fear of serious bodily injury. And apparently, investigators in the Austin Police Department see the case similarly. A source within Austin law enforcement tells me that the lead investigator on the case, an experienced and decorated detective, did not see probable cause to charge Perry after extensive investigation that included video evidence, nearly 50 witness statements, and forensic and ballistic analysis of the scene. So I thought perhaps this one would be a rare self-defense case that rightly fades away. A terrible night for everyone involved, but a just outcome given the circumstances of an attack on a man and his response to protect himself. But wishful thinking, of course, because this is Austin after all. So you may be wondering, how would an Austin district attorney let that happen? He wouldn't. You're right. And so news broke last week that a grand jury has indicted Sergeant Perry on charges of murder, aggravated assault, and misdemeanor deadly conduct. after a presentation of the evidence from District Attorney Jose Garza. And not just any district attorney, but a newly elected Democratic Socialists of America member district attorney, and a guy with a particularly kind way of describing Garrett Foster's activity that night.
Mr. Foster was fatally shot while participating in a protest in Austin in July 2020.
Yes, he was just suddenly and fatally shot while participating in a protest. What an unfortunate event, with no mention of surrounding a car and stopping that car and beating on that car and advancing on that car with a rifle in hand and allegedly pointing that rifle at the car, all while saying that everybody's too big of a pussy to stop him. Now, it stands to reason that sort of generosity to Foster is what the DA presented to the grand jury as well, but we don't know what information he presented to secure these charges. And of course, that information is presented at district attorney discretion. So that guy picks what the grand jury sees, and he also picks what the grand jury does not see. Perry's defense team is accusing the DA of getting choosy and one-sided with the evidence he presented, as well as making the unusual move of refusing to allow Perry's defense team to submit a written presentation to the grand jury. The DA denies cherry-picking the evidence, but questioned by a reporter at this press conference announcing these charges, he makes a statement that implicitly confirms it.
It is true that Mr. Perry's attorney presented our office with a packet of information, and the overwhelming majority of that information was in fact presented to the grand jury for their consideration.
Well, even the overwhelming majority isn't all of it, so what did you exclude is the obvious follow-up, which a reporter asks, and the DA won't say.
Well, generally the law prohibits us from speaking in any detail about what information a grand jury considered. What I will say generally is that of the information presented in that packet, the only information we did not present to a grand jury is information that would not be permitted in a trial.
Now, if you doubt that it was simply courtroom admissibility that guided this prosecutor's decisions to include or exclude certain pieces of evidence, you're onto something. And I'll give you even more reason to doubt. That same source within Austin law enforcement, who I believe to be credible and accurate, tells me that the district attorney's presentation to the grand jury included no video of Garrett Foster advancing on Perry's car with the rifle, and no statements from witnesses who say that Foster pointed the rifle at Perry. And that veteran detective at the police department was only given under an hour at this multi-day presentation to speak, and was not allowed to give his ultimate findings of no probable cause to charge Perry. And that unfortunately infamous video of Foster calling his political opponents pussies, that was never played. And strictly speaking, that video is not relevant to the crime, I know. You can call someone a pussy. It's still an allegedly free country. For now, that is not a crime, nor is it indicative of any other crime. It is legally irrelevant, even if it is highly comically relevant. But because of that irrelevance, it makes sense that the DA would exclude that video from the case presented to the grand jury, you might think. Sure. Except that the DA did include comparably irrelevant evidence against Daniel Perry. According to this source, the DA's case rested mostly on the tear-jerking testimony of Garrett Foster's family and friends, not video and photo evidence of what actually happened. These were just stories of what a good guy he was most of the time when he wasn't falsely imprisoning people with an AK. Somehow that's relevant. And so is this tidbit. The district attorney presented the fact that when police searched Perry's car upon his voluntary surrender, they found what the source says the DA presented as some sort of smoking gun, the universal scarlet letter for terrorists, a MAGA hat, among his personal items. Okay, so video and photo evidence of what happened, not relevant, but implicit political affiliation of the accused, highly relevant. That is not the acquisition of the truth. That is not the application of the law. That is just political war making. And if you need further demonstration, consider this additional inconsistency in the DA's case. There was actually a second shooter that night. Foster and the mob advanced on Perry's car. Perry shot Foster and drove away to safety. and another man in the crowd returned fire at Perry's car, leaving the scene. According to this source, that person who shot at Perry's car fleeing the scene is of lefty political persuasion, and that individual has not been charged and likely will not be charged, despite the police department telling the DA's office that firing a handgun at a moving vehicle in a densely populated and chaotic area was reckless. Now, maybe you think that second shooter doesn't necessarily know exactly what's going on, and he has a self-defense right just like anybody else does, and I agree that he does, but I'm not convinced that shooting at a car leaving the scene is self-defense, at least in the same way as shooting somebody aggressively approaching you, possibly even pointing a gun at you. But more importantly, I can't see any self-defense philosophy by which Perry is a murderer, but the second shooter did nothing wrong. Now, before we let the pessimism flow, it is important to remember an indictment is not a conviction. The standard of proof is much lower to bring the charges than it is to convict on the charges. And of course, the DA choosing the evidence means that key pieces of the defense have yet to be heard by a jury. So there's plenty of reason to believe that the outcome will be different at trial or in some sort of plea deal beforehand. But don't fully discount the pessimism either, because there are plenty of questions to ask about why such charges were ever even brought in the first place, how such a clownishly partisan DA ever even got elected at all, and of course, the overall influence of politics that overrides the law, the evidence, and the truth with frequency these days, often with media and politician assistance and mob celebration. Because I thought that despite the politics and the narrative and the agenda in the Derek Chauvin case, that those important things, the law, the evidence, the truth, those things would still win out. And that was a clearly foolish prediction that I won't repeat in this Daniel Perry case. And we'll see if the law and the evidence and the truth still matter, or if Garrett Foster was actually kind of right. And we all are too big of pussies to stand up for them. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Gab. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.